Welcome back to UPC Insights, the podcast where we unpack developments and case law from the Unified Patent Court. I'm today your host, Tilman Pfrang, European patent attorney and UPC representative. Today's episode is all about facts, or rather how you deal with them when they're alleged against your client. We'll dive into the evolving UPC approach to burden of proof, fact-finding, and one key message for parties and practitioners alike: don't plead, ignore it. Joining me to shed light on this topic is my colleague Moritz Bloser, experienced patent litigator and UPC representative. Moritz, great to have you here.
Hello, Tilman. Great to be here. Great to be back. And also given the chance to share some new insights on the recent developments on this topic of today.
Moritz, first question. Let's start with the basics. When it comes to facts in UPC litigation, who has to prove what and how does the UPC assign the burden of proof?
Yeah, that's a great starting point. In UPC litigation, the general rule is quite similar to what we know from the national proceedings. The party that asserts a fact has the burden of proving it. So if the claimant alleges that the patent has been infringed, it also must prove the facts that would support such infringement. On the other hand, if the defendant raises a defense, so like non-infringement or on invalidity, it bears also the burden of proof for the elements he wants to bring up. Also, in contrast to German proceedings, you do not only have to prove the facts that have been contested, but also already facts that are likely to be contested by the other party. So this means that I already have to, at least to some degree, anticipate which facts might get contested, and there I already have to provide evidence in my pleading for the statements I make for which I think the other party might contest them. But honestly, we actually do the same in Germany usually. So when we make a statement, we provide usually already the evidence, the facts there. But in Germany, it would be sufficient to only have the allegations to be conclusive and coherent. We don't need to prove them at the beginning. So the rule of the UPC is codified in Article 54 of the UPC agreement, which, as I said, states that the burden of proof lies with the party who makes the assertion. However, the court is not strictly bound by such formalities and has some discretion at least. Also in Article 55 of the UPC agreement, it is codified that there's also a reverse of the burden of proof, at least in cases involving process patents. There, similar to Germany, it's presumed that the patented protected process, which was used for an end product, if the end product is identical, the defendant needs to prove that it was not produced by this protected process. So again, the UPC's key concept regarding the burden of proof is that it lies with the party who makes the assertion.
Okay, great start. My next question is about pleading ignorance, or for our German listeners, bestreiten mit Nichtwissen. So pleading ignorance. In a recent order by the Düsseldorf Local Division, actually, the court made it very clear that simply stating "we cannot comment" is not enough. Can you walk us through the key takeaways of that decision?
Sure. And it's actually a really important decision, especially for those of us who've been litigating under national systems and are now adapting the UPC practice. This was a question which was unclear until now. So in this case, the court took a quite firm stance. They said that simply saying "we cannot comment" or "we do not know" is just not sufficient response to factual allegations under the UPC rules of procedure. In German practice, as you already indicated it, we are familiar with the concept of bestreiten mit Nichtwissen, so pleading ignorance, basically a way to deny facts by saying they are outside our knowledge or your knowledge. And it's allowed into German rules if you are not expected to know them and have already made reasonable efforts to obtain the necessary information and could not get them without your own fault. But under the UPC framework, this is not admissible. The judges in Düsseldorf made it quite clear. If you don't actively and specifically contest a fact and also explain why you're disputing it, the court will treat the fact as admitted. That's based on Rule 171.2 of the Rules of Procedure. In the case we're talking about, the defendants had questioned the authenticity and legal effectiveness of multiple license agreements, raising doubts on signatures, authority of the signatories, and even whether these submitted documents correspond actually to the original documents. However, they did not provide positive evidence or detailed reasoning why they actually believe that there might be discrepancies in these documents, in these license agreements. So the court found this tactic to be insufficient and made quite clear that the UPC's rules of procedure do not provide for a right to just plead ignorance as a substitute for proper contestation. In practical terms, this means that you can't simply say, we cannot confirm that. If you do this, the court might proceed as if you have admitted the contested agreements here, and say that they are in order, because without didn't probably engaging with the allegations, that's not sufficient. So in a nutshell, pleading ignorance, as we know it from German national proceedings, is just not allowed at the UPC, at least now to the Düsseldorf Local Division, however, only a first instance court. So it could still be the case that other local divisions or later the Court of Appeal might see it differently and come to another conclusion in this regard. We will need to see.
Great, Moritz. You touched on this, but can you further elaborate on the question what actually happens if a party does not contest a factual allegation at all? And how strict is the UPC in applying procedural consequences for silence or vague denials?
I'm happy to. The UPC is very strict in this regard. If a party fails to contest a fact or does so in a non-specific or evasive way, the UPC may consider that fact to be admitted. That's similar to the German civil procedure, actually. Here also Rule 171 of the Rules of Procedure allows the judge to disregard vague submissions, it says they're not specifically contested, and also treat unchallenged facts as established. So vague denials or silence are neutral as the UPC. They can be quite dangerous. They can undermine a party's entire argument and also limit their ability to raise further objections later.
So there is, I understand, too late at the UPC when it comes to presenting evidence or contesting facts. This is what you're saying, right?
Yes, absolutely. That's definitely a too late at the UPC. This follows from the front-loaded procedure which we have at the UPC. So that means that you need to provide the bulk of your factual allegation, the evidence, legal arguments, and so on, also in the written phase of the proceeding, so at the beginning. This means quite before the oral hearing. And also within these written proceedings, you need to provide all your factual allegations and evidence as early as possible within the written phase. So raising new arguments or suddenly contesting facts at the oral hearing without having them made earlier during the written submissions is usually not allowed. The court can and often will refuse to consider them unless you can explain why it wasn't possible to bring these points earlier and during the written procedure. This again reinforces the importance of early preparation and completeness in your written pleadings.
From your practice, what are the do's and don'ts when it comes to contesting facts in writing? What level of detail is needed for denial to be admissible?
Yeah, that's a very important and practical question. When contesting facts in writing for the UPC, specificity is everything. It's very important. So denial must be specific, substantiated, and responsive. If you're just writing it's denied, it's just not enough. The court wants to see why a fact is contested and ideally what the alternative version is. Think of it like this. Treat your denial as a counter assertion backed by reasoning and, where possible, evidence, of course. The level of detail needs to mirror the assertion made by the other side and also the depth of evidence the other side has provided. So typical do's would be that it's, as I said, important to be specific. If you deny a fact, explain why the fact is wrong or incomplete, taken out of context, or based on an incorrect assumption. Also, offer alternative narrative. The court expects not just a denial, but an explanation. If you contest a claim about how a product works, explain how it actually works or does, in your opinion. Then always support your statements and denials with evidence as early as possible. This means to back up your denials with documentation, expert reports, or internal data, etc. This makes the denial more credible and helps shift the burden of proof to the other party. Finally, use structured responses. So try to mirror the allegations in your opponent's pleadings by corresponding paragraph by paragraph statements in your briefs. Potential don'ts could be, like I already said, don't plead just ignorance, unless it's genuinely unavoidable. And even then, explain why you can't commit. So for example, lack of access to certain data. But yeah, we've talked about this. Further, don't delay your denials. Untimely contestations can be ignored as also entirely. Finally, don't rely on boilerplate statements. Phrases without any factual engagement are just insufficient for the UPC and should therefore be omitted. The court wants substantive responses and not just legal cliches.
Some say, Moritz, some say the UPC's approach echoes German-style consequences for uncontested allegations. Would you say that is a fair comparison, or are we seeing something distinct emerge, maybe?
Yeah, at least to some degree, it's a fair comparison. There's definitely a surface level similarity between how the UPC is handling uncontested allegations and how the German Code of Civil Procedure operates. But still, I would say that we are not seeing a copy paste here. Rather, the UPC is developing its own procedural identity, though it does lean heavily on civil law traditions, also including the German practice, of course. The UPC is, however, I would say has more emphasis on structured written procedure and judicial case management. Also, there's much stronger emphasis on providing facts as early as possible. New facts and arguments that are being filed later can easily be deemed as filed late. In German proceedings, for example, usually everything that you argue prior to the oral hearing is not late. Also, legal arguments in German proceedings can never be late. So, for example, claim interpretation, so a very basis of patent litigation, is understood as a legal argument in Germany. So everything you say in regard to claim interpretation will never be late in German patent infringement proceedings. At the UPC, however, also arguments and claim interpretation can be late if not filed in time. So that's a very big and key differences, for example. Yeah, so while German practice certainly influences the rules, the UPC is building, I would say, a hybrid system that rewards an early and clear fact management and punishes delay, regardless of the national background.
Looking ahead, how should parties prepare their written pleadings, especially replies and rejoinders, to avoid procedural pitfalls and protect their factual position? That's my next question.
And that's a crucial one, to be honest, because in the UPC, your written pleadings are really the foundation of your case. Given the front-loaded structure and the court's growing procedural discipline, parties need to approach replies and rejoinders with as much care as they would in the final hearing. So that could mean that mapping out the factual case in advance and bring forward all arguments and counter-arguments as early as possible is actually key at the UPC. Here, what you sometimes do maybe in national proceedings, doesn't make sense, or it's not advisable usually to hold back evidence or arguments for strategic surprise. Like I said before, the UPC penalizes late submissions unless strictly justified. Also, as already explained, be explicit in your denials. When contesting facts, provide reasoning and supply supporting evidence where possible. Further, working closely with technical experts and witnesses from early on is very important. This also means to introduce written statements with the pleadings in which you're naming these witnesses. So here we can have such written statements, which we usually don't have, for example, in Germany. Also, try to anticipate counter arguments proactively already with your pleadings. And finally, anticipate the next procedural steps. Each pleading should be prepared with an eye on the next one. Potential pitfalls, which should be avoided, of course, are to assume that the oral hearing is a second chance. It isn't. New material introduced late will likely be rejected, as explained earlier. Also, just repeating your own case without addressing the opponent's statements and allegations is not going to fly with the UPC. This only weakens your credibility and can be treated as a failure to contest. Further, neglecting factual nuances. Denying the opponent's version is also not enough. You need to offer your own version of the events to help the court understand the dispute and better your position in it. In a nutshell, treat replies and rejoinders not as a defensive afterthought, but as a strategic document. This is your opportunity to shape the factual record that the court will use to decide the case. The more clearly you can define the battleground, the more persuasive your position will become.
What should international teams, especially those used to more lenient common law standards, I'm thinking of the United States, for example, keep in mind when preparing facts and evidence for UPC proceedings?
Yeah, common law teams often expect a more flexible and trial-heavy process. So in the US or in the UK, you have oral hearings that last a week or 2 weeks or even longer. So at the UPC, the written phase is actually the main battleground for your proceedings. Also, we don't have a US-style discovery or a UK disclosure. Oral hearings at the UPC are concise and judge-led. One of the biggest pitfalls we see is to underestimate the procedural discipline of the UPC, especially if you are used to a more flexible common law litigation. So things international teams should adapt or must adapt to or adapt by are that there are actually no fishing expeditions. Front-loading factual investigations are required from early on. Also, it's important to see the statement of claim as a place to tell your full story. Don't hold back. Therefore, avoid vague pleadings and over-reliance on future hearings. The oral hearings often short and focused at the UPC, typically only 1 day. So the written phase is where the case is really decided. Finally, align with procedural expectations early. The UPC follows very strict case management rules with strict deadlines. Finally, so the best advice I can give to international teams partnering with experienced local counsel to navigate litigation at the UPC successfully.
Thank you, Moritz. That brings us to the end of today's episode on fact pleading, burden of proof, and procedural strategy at the UPC. Thank you for your valuable insights. It's clear that the Unified Patent Court expects parties to be precise, prompt, and disciplined, especially when it comes to dealing with alleged facts. And to our listeners, thank you for tuning in. If you found today's episode helpful, please subscribe, share it with your colleagues, and stay tuned for our next edition of UPC Insights, where we continue exploring the practical realities of litigation on the UPC. Until next time, and thanks for listening. Und auf Wiedersehen.
Vielen Dank.